Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk a little bit about naturalization. I suspect that, a wide range of people who have applied for naturalization have not heard back from USCIS after their interview. So, for example, let's say you just had your interview on May 1st, and 4 or 5 months have passed and you haven't heard anything. You called up and they said something to the effect, we are checking to some security databases, or the name popped up in one of our databases and we're following up on it. Well, first of all, if that were really the case, let's just pretend that you were not you, but some political figure, or some buddy who's going to be speaking with a political figure in the U.S. They'd be able, being the government, would be able to find out the reality of your background within a matter of days. It would not take months, and the higher the security that's involved, the faster that it will take. So there are various statutes in federal law that will permit you to go to federal court and sue immigration in federal court. So, there's different types of actions that can be taken, but the key date is that if you've waited more than 120 days after your interview and there's no decision that has been made, then you are now eligible to actually file a naturalization, basically a naturalization action in federal court. And the federal judge will then decide the naturalization, or will send it back to USCIS with instructions. So there's no need to wait month after month, year after year, in order for you to determine when you are, if you're eligible or not eligible. And I can't tell you how many times people say, well, if we file an action in federal court, isn't that going to make USCIS mad? Well, the answer is that what it does is it gives leverage. A lot of times we file these actions in federal court, and the next thing you know, there's a decision that's made 3 days after we file it, or it's made a day before they're supposed to answer. The reality is, most of the time, is the U.S. attorney who represents USCIS basically doesn't want to stand up in front of a federal judge and go, Your Honor, the reason it's been pending for 6 months is because the name popped up on a database and we are investigating. And then the judge will go, well, popped up on what database? Investigating what? What steps have you taken to actually investigate and to actually look? So they don't want to be in that position. So, the reality is that this judicial review is available, and unlike most areas of immigration law, which takes longer, it only takes 120 days to vest jurisdiction in the district court. Now, of course, you have to apply for the relief in the jurisdiction upon which you live. You can't file for this district court action in New York if you live in Los Angeles. So it will have to be filed, and of course you have to show that you went to the interview within 100 or prior to 120 days before it's filed. My practice is usually to send USCIS a letter initially stating that this is what we plan on doing. We'd like you to make a decision. Please make the decision so we don't have to go to court. And if it's just blatant that they're not, cooperating, or there isn't any real reason why it has gone, you can actually request EJA fees, which are attorney's fees in the federal court. And if the federal judge determines that essentially the actions by USCIS were unwarranted, the federal judge can order all of your attorney's fees back. So that might be another reason in which USCIS would be dissuaded and forcing you to do it. So there, you don't want to file. This is why I need obviously to give a consultation, but you don't really want to file an action in federal court to force the issue if you're a borderline case. If you don't really have a good naturalization case. I mean, the reality is you shouldn't file a naturalization case in the first place if there's not a very decent chance it would get approved. But there are situations where you would have to on a case-by-case basis. Now, let's say that the decision by by the federal court is made, but there's a little issue that might be wrong, or there might be some item that was left off. You, of course, can make a motion to amend that decision in which to add or take out the parts that you find objectionable or questionable, and then hopefully that would be granted. Now, there's a long time in which jurisdiction vests. Let's go on another subject here. If your application is denied, let's say, and what happens is you get the naturalization denied. They file with you, or they send you a denial, and they say you can file to basically appeal on what's called a 336. If you appeal and that is denied, and really what it is a petition for rehearing of the naturalization, but assuming that's denied, then you have up to 6 years to file in federal court, basically to oversee and to change or make a decision that you believe is warranted. Because every now and then you just get officers that they're predisposed to deny the case the moment you walk in the door. It doesn't matter what you say, it doesn't matter what law you present, they're just going to issue a denial no matter what. And if you answer the reason why they shouldn't deny it on that basis, they'll find another basis. So the good part is, if that all happens, that gives you a ground in which to go into federal court and try to basically get the relief, being a U.S. citizen, that you believe that you should get. There's all kinds of other reasons to go into federal court too. I mean, in each case, again, is individually on its merits, but challenging the denial of moral character. Okay, there's certain circumstances where you should not have been denied based upon moral character, or that the decision itself refers to something that happened in the past that shouldn't be referred to, in the capacity of moral character, and so forth. So, if you're having a problem with naturalization, and if you're not getting a decision, or if you received a denial on the motion or on the petition for rehearing, that's not the end of the road. In fact, in some cases, it's the beginning, because you have to get to a federal judge to get the real decision sometimes, and that's the way it is. But the good part is you have the ability to do that. In some countries, some places, once somebody at a administrative level says no, that's the end of the road, and there's nothing you can do about it. But in the United States, we do have options to try to get the relief, that hopefully you deserve. So if you like the video, click like, subscribe, and also you can call my office anywhere, anytime for a consultation, which will be set up for you at a mutually convenient time. Okay, more in the coming videos.